Thank you for coming to Citizenship Day. My name is Tamla Lloyd, and I am a student clinician in the Immigration and Human Rights Clinic here at Florida Coastal. Today, I will be talking to you about the process after becoming naturalized. Upon becoming naturalized, you would complete Form N-600 to apply for a certificate of citizenship for your child. We will begin by talking about who should file Form N-600. If you have a child born outside of the United States to you, the U.S. citizen, or the child automatically became a citizen of the United States after birth before turning 18, that child may file Form N-600. As a parent or legal guardian, you can file this form on behalf of your minor child. Furthermore, if you have a child claiming to have acquired U.S. citizenship through you, the U.S. citizen parent, and that child is now over 18, you may also file Form N-600. That child must have been under the age of 18 on February 27, 2001, which is the date the Child Citizenship Act came into effect. Citizenship law has changed over the years, so it's important to take a look at the law in effect at the date of your child's birth. There are certain conditions that need to be met if your child is claiming citizenship after birth but before reaching 18. For instance, you as the parent must be a U.S. citizen. That child must be your biological child. That child must be lawfully admitted to the U.S. for permanent residence, and the child must be living in the U.S. in your legal and physical custody. Adoptive children may acquire U.S. citizenship through his or her adoptive U.S. citizen parents, depending on the law being applied. However, stepchildren cannot acquire U.S. citizenship under this provision. If you are a U.S. citizen parent or legal guardian who has legal and physical custody of an adoptive or biological child under 18 years of age, you can file Form N-600. Let's now take a look at who should not file this form. A child who does not have at least one biological or adoptive U.S. citizen parent, a child of a U.S. citizen parent who regularly resides outside of the U.S., a child born of wedlock, not legitimated prior to his or her 16th birthday, and the U.S. citizen is the father. If you're seeking to replace the lost or stolen certificate, you should refer to Form N-565. You should also not file this form if you've already filed and received a decision from USCIS, or this form will be rejected. There's certain required evidence while filing Form N-600. For instance, photographs, which should be identical, passport style, and taken within 30 days. A birth certificate or record of the child and you, the U.S. citizen parent. A marriage certificate, documents showing marriage termination if applicable, proof of citizenship, proof of required residence presence in the U.S., and evidence of all legal name or name changes if applicable. If the required documents are unavailable, you would need to provide a written explanation and submit secondary evidence. Types of secondary evidence may include a baptismal certificate, school record, census record, or affidavits. The filing fee for Form N-600 is currently $1,170. Listed here is the website where the form can be located, as well as the address to mail the completed application. As previously stated, the price of the form is currently quite expensive. Thankfully, Form N-600 is one of the forms eligible for a fee waiver. Fee waiver Form I-912 provides assistance for anyone who is unable to pay the filing fees or biometric fees for an application or petition that is eligible for a fee waiver. However, you must clearly show that you are unable to pay the fees. And to file the completed Form I-912, you should attach it with all supporting documentation to the application for petition for which you are requesting a fee waiver. Please do not submit your Form I-912 without a completed application or petition. I've also provided you here with the web link to locate Form I-912. Please also keep in mind that there are 3 bases while filing the form for the request for fee waiver. The first one being the means-tested benefit. Your child must be currently receiving a public benefit, such as Medicaid, or benefit from supplemental nutrition assistance, temporary assistance to needy families, and supplemental security income, among others. Secondly is the household income. This is based on the income on the household size, and the household income should be at or below 150% of the federal poverty guidelines. It's important to take a look at Form 864P, which provides the poverty guidelines. Finally is the financial hardship. If you are having a financial hardship, you would need to provide details about the financial hardship, whether it relates to medical expenses of family members, unemployment, eviction, or homelessness. This concludes my presentation on the Form N-600. I hope this has been helpful. Thank you for watching and listening.